Yes.
Yes, my lord.
What
I'm
is this
happy with
matter?
the petitioner, my lord.
My lord, before, my lord, may I, my lord, this is.
Just let us see what is the
Apologize.
matter.
I apologize, my lord. This matter has already been taken. See, the Honorable Supreme Court is in season of the.
What is the matter? That is what you say, Honorable Supreme Court. We don't know.
I apologize.
That is what we wanted. It relates to what? This again the postpone or what?
My lord, there is Supreme Court order, there is a parts.
Or what is the
NEET, my lord, NEET, that
NEET.
NEET examination.
Sir, yesterday, I believe that order has been passed by the Supreme
Yeah,
Court.
that is what we are
That is
saying.
the
NEET
order.
examination.
163 candidates, if I correctly remember.
Yes, my lord. And it has
to
been
sit in the further examination. Declared result would be declared on 30th. And there was no stay on so far as the counseling is concerned, which should start in the first week of July.
Lord,
My lord,
what
returnable on the
remains?
8th, my lord. Returnable on the 8th. The matter has been made returnable on 8th of July. My lord, kindly comes to the last page.
What you are raising?
Lordship, with the order of the Honorable Supreme, with due respect, my lord, the basic issue has not been solved. Only 1563 candidates issue somehow has been resorted with fresh examinations for those candidates with 2 options. Either they will stick to their previous marks without any grace, or they may appear to the new examination. That is the thing. But my submission is a totally, Lordship, in a different context, my lord.
কি ইস্যুটা আছে
My lord, may I submit, my lord?
Still pending. Come up petition of the Supreme Court saying that I would bear the otherwise getting you should come up. He's saying it's a different certainty. If this issue has not been resolved by this order, that is not the solving question. Maybe resolve it. If the issue is unable to say.
Yes.
My lord, may I submit, my lord? I appear on behalf of National Testing Agency, respondent number 2. It must be brought to your lordship's notice that my client has already filed a transfer petition seeking transfer of this petition also before the Honorable Supreme Court today. To be tagged with the other petition.
Because I have seen this order.
Lordship.
Only this order was passed in relation to that particular grace mark. And the other issues, as per the submission of the petitioner therein,
that is leakage of
kept
yes, leakage of
kept open.
Leakage of
and
marks.
then for that the response was sought.
Lordship.
The affidavits to be filed.
Lordship.
And then the matter has been made returnable on 8 July.
Yes.
What you have raised, grievance, leakage.
Lordship, at the very first.
My lord, another thing, my lord, the maintainability of this, at that part, they have already moved Supreme Court because who is the petitioner before lordship? Kindly see. I mean,
who?
A law student. Kindly come para 1 of the petition.
The law student has to do with this.
and most of the paragraphs are verified to be true to her knowledge. This is a publicity interest litigation, not a public.
So you have already filed it.
Yes, I have. We have.
Lordship, may I submit, Lordship?
Yes.
Lordship,
When it is listed,
My lord, it was filed today only. Now diary number will be allotted. Thereafter, it will be converted as a civil writ petition. It's a,
no, when it is
but
supposed
date
to
has not been given because they will find some, my lord, defects or that has to be removed. That's all. It has been filed today only. In fact, this writ petition was served, my lord, on 11th.
Yes. Yes.
Lordship, most probably, if I'm not wrong, my lord, the first bill was filed before this honorable court during the summer period, my lord. And most probably, this is the first case in which, Lordship, it is referred in the page 217, my lord.
My lord, so far that part is that writ petition, separate transfer petition has also been filed.
Lordship,
এখানে হচ্ছে যে marks, examination centers details of OMR, individual login এর উপরে তোমাকে হচ্ছে যে তুমি এটা পাবলিশ করতে পারো along the complete details of just find the applications. Compensatory marks, it has gone. It cannot be done. You cannot. Manage.
হ্যাঁ গ্যারান্টি এক নম্বর সুমন সুমন সুমনের কাছে যাবে
Sir, what interim order you want at this stage can't be granted.
no, my lord.
Sir, so far as the first prayer is concerned, it is of a serious nature that requires everything. You'll have to show the rules, you'll have to show everything that requires that everything has to be published. Second B has now been taken care of by the Supreme Court. We can't now touch. Prayer, come to your prayers. Prayer A, show us that that is a mandate of the statute. B, now taken care of by the Supreme Court, we can't touch it. So far as grace marks are concerned, compulsory marks. So far as the C is concerned, very difficult. That's the final relief cannot be granted at this stage. So far as the D is concerned, that also requires the entire affidavits have to be filed by them. Otherwise, we can't decide it on that. Interim order which you are talking about, I think the Supreme Court has already permitted the counseling to be held. So we can't pass an interim order at this stage because it will be a direct in contradiction or contravention with the Supreme Court order. Then what remains? The affidavits. In the meantime, if it is
No, my lord.
if it is thought, then it has to go there. It has to go there.
Lordship, firstly, Lordship, there is no stay order that any of the high courts will not hear the matter.
I am not
My
saying
submission,
so. I am
Lordship.
not saying so.
My Lordship.
But what I am saying is that if we take this, the PIL, the prayer wise, I have already indicated. Please come to your prayer. First prayer which you have sought for, show us the rules or statutory regulation which says that they have to make a publication. Show us the rules. Show us any rules or regulations which says that A has to be followed. Essentially is a question to be decided at the time of hearing. Then come to B. Come to B. B, the apex court has now passed an order yesterday. Compensatory marks. Compensatory marks have gone. Now we can't touch it. We are bound by that judgment. You are also bound by it. You can't do it. Then come to C. That the final relief cannot be granted. What interim order? We can't. You wanted to scrap. That can only be done after the affidavits are filed. Then D. It is also a final relief. Then come to E. Is a normal order. F, you wanted that counseling should be stopped.
No, Lordship.
It is what you want, not to take any further steps for counseling. The apex
Lordship,
court has taken note of their submission and did not interfere.
Lordship, may I make the at the initial level submissions, my lord?
What?
My submission is on the contradictions and anomalies that still persists within their system. And besides these 63 candidates, there is the basic issue is the equity and equality, my lord. Firstly, my lord, they have relied on certain judgment of the Honorable Supreme Court in CLAT case. And issues apparently, as per their admission, both are same. There was a loss of time. There is, as per their claim, there is loss of time.
That,
When
my
the
lord,
first, let me conclude, please. When the result was published on 4th, and incidentally, that very 4th day is counting of parliamentary election was during the entire India was very much otherwise mentally set. In this situation, the result was published.
Very
I don't,
difficult.
but that is maybe coincidence. But my submission on that very point, my lord, they have beaten their own drums with their numerous records that how they conducted the and whether there was anomalies or not or something else, and there is not a single whisper, my lord, that they constitute some committee. That committee considered the grievances of the and all these things. There was no whisper. Result was published on 4th. When then some cry came out, then they came with some clarification the 5th. And on that very date, my lord, I've annexed that
No, that's true. Now,
my
please
submission in
consider.
this context, my lord, they have relied on a certain order of the Honorable Supreme Court, judgment of the Supreme Court. And that very judgment has gone into the very equity of the issue, that if some grievances are there and that authority goes for their own internal audit, then it is upon them to decide that all other issues be taken into consideration.
These are
And
all
then-
the closed issue after this judgment of the Supreme Court.
My lord,
Please consider.
yes, my lord.
Please try to consider. You have come at a point of time when there was nothing. You may have raised a very genuine grievance. Now it appears that the matter was also taken cognizance of by the apex court in a public interest litigation under Article 32. There, the apex court yesterday passed an order where the NTA, the National Testing Agencies or whatever, they themselves have found that there was a fault or a whatever, the error committed by them. They, in their affidavit, which is quoted in extenso in the order, they themselves has admitted that this is what the problem was. And then they also disclose that so far as this compensatory marks are concerned, we have decided that these are the fault which was committed. We cannot grant that. And they say that these candidates who have been awarded this compensatory marks, they should be given an opportunity that if they want to enhance their, the rank or the numbers which they have opted, they must be permitted to sit in the examination. The apex court has accepted this. The apex court accepted this, and you will find that the recording of the submission of the learned counsel for the NTA in the internal page 5 of the judgment of the Supreme Court, it is said that he stated that the retest will be notified today itself
Yes.
and would be held on 23rd of June 2024. The result of the same would be declared prior to 30th June 2024, so that the counseling which is likely to start from 6 July onward would not be affected. Taking note of this, the apex court says that having considered the submissions and the materials placed on record, this court finds that the recommendation made by the committee on 12th June, which is recorded, after deliberation held on 10th, 11th, and 12th, are fair, reasonable, and justified. Accordingly, the NTA may proceed for holding the retest as indicated above. And then we dispose of the writ petition number such and such. Then, so far as the other writ petition is concerned, the issue of compensatory, apart from the issue of compensatory appointment, with respect to the other issues, the represented respondent will file their respective response within 2 weeks. Issue notice to the unrepresented respondents, returnable on 8th July. So other issues has also been shaped open by the Supreme Court in that particular. But so far as compensatory marks issue is concerned, it is now set at rest. You can't raise that. The bottom line of this judgment is that the Supreme Court also declined to pass any interim order, is staying the counseling, which is supposed to start on 6 July, and then matter is returnable on 8 July. So it is better that we can't pass any interim order as you prayed for, staying the counseling, because you are moving it for the purpose of interim order.
Lordship, may I submit?
You want an interim order?
No, my lord.
Then affidavits should come. Let them file an affidavit.
My lord,
Let us see.
may I just submit one point, my lord? Question is, so far lordship has said, I have no objection to that point.
Sir, kindly visualize. The question you are raising is for the purpose of interim order today.
No, my lord,
when no interim order is required,
lordship, when I
then
made the
all
submission,
questions have to be decided after exchange of affidavits.
my lord,
In the meantime, if it is transferred.
lordship, when this petition was filed, subsequent developments have occurred, and that was naturally could not be taken into consideration while preparing my submission.
You want
In
to file
this
a supplementary affidavit? We are granting you leave to file a
Now,
supplementary.
my lord, in this my submission on this point, my lord, I have no objection to that very point, that that very 1563 candidates are allowed for the second time. This is not my concern. I am not praying for that. There should be a state on that re-examination. This is not my point. My submission only on
We can't grant.
no, my lord. My submission on this point is only on equity, my lord. If they are candidates, there should be a determination that they have taken the concern of pan-India, and only there were the 1563 candidates. There were no more candidates. There are no more case pending. There are no more instruction upon.
Can we go into this?
My
I'm
lord,
asking you.
this is lord.
I am asking after the apex court has closed that issue, finally, can we go above the order of the Supreme Court?
My lord,
You are saying this point was also there, that why restricted to 1563? Why not overall? Supreme Court did not accept that. That means impliedly discarded that. Then we can't.
My submission, my lord, it was their submission that they got cases from Chhattisgarh High Court, Delhi High Court, Haryana and Punjab High Court, but they did not refer the matter that there was another case at the Calcutta High Court, and there was a specific judgment to that direction. I'm just referring lordship's attention.
Suppose
That's a judgment.
that being the position, can it override the judgment of
Now,
the
my lord,
Supreme Court? I am asking.
my
Very simple question to you, sir. The order of the apex court, which is now prevalent, is binding on the High Court as well.
No, my lord, my submission is,
If there is any order contrary to the order of
if
the
I am
Supreme
not
Court,
wrong,
what would be the effect?
I have not, Lordship, if I have not misconstituted the reading of the A, otherwise, my lord, there is no restriction that other issues of other candidates cannot be considered.
Supreme Court
Yeah.
has already said that other issues we wanted to decide, keep it open.
No, my lord, I'm I'm not talking about the irregularities, corruptions, manipulation, all these things. This is the another aspect, my lord. My submission is that there may be some other candidates in the equally same circumstances.
But those have to
They
be.
have already moved before the lordship. Look, there is
They-
order already, my lord.
What
This is the
order?
order, my lord.
My
What
lord,
order?
my lord,
This case was moved on 28th, my lord. Fifth,
lord is, my learned friend is not right. Kindly come
and
to
it
paragraph
was heard
page
on 6th.
196 once.
My
Page
lord, it was
196.
heard on 6th.
Page 196, kindly come to 196.
Order was
Because-
passed on 6th, my lord. On that very date, it was their consideration that this matter will be considered. This is their view. This is their submission. Now, if 1563 candidates there, this candidate is gone. There is another case, my lord. These candidates are gone.
It means you'll have to go there. Are you not realizing you are a responsible officer of the court? You
Yes,
are
my
a
lord.
lawyer, you know the law. If the issue was restricted to 1563 and the order of the Supreme Court is in relation to 1563, Supreme Court says no other candidate will be permitted to sit in the re-examination. Can you now say that you should be also be permitted? I'm asking you. Then you'll have to move the Supreme Court and ask for
My lord,
further
Supreme
relief.
Court considered one aspect. Kindly come to page 196. What was this result was declared on 4th June. Then that compensatory marks for loss of time. Supreme Court considered this letter also. Read 196. They have annexed. Kindly come to para 2. Compensatory marks for loss of time. The few writ petitions were filed by candidates of NEET before the Honorable High Court of Punjab, Haryana, Delhi, Chhattisgarh, raising concerns of loss of time. During the conduct of NEET exams, it's on 5th May. FU exams. The concerns raised by the candidates, though.
File your affidavits. He is not asking for interim order. Then
My
you
lord,
have a
my
statute to file an
respectful
I-
submission.
At this stage, my lord, issues are so serious and so anomalies. There is so issues of corruption. At least some impartial inquiry body be SIT be formed. My submission is the CBI be asked to.
Let us have the evidence. Let us have the documents in this regard regarding some kind of corruption, some kind of malpractices, some kind of nepotism, some kind of favoritism. Unless that is there, they have to disclose their affidavits.
My
We
lord,
can't-
there
we
was
can't
no
pass an order
complaint.
for it.
There was no complaint. There was
On a drop of the hat. We can't.
Problem, my lord.
No,
It was
we can't.
government's stand.
Sorry.
It a government is withdrawing, but
My
not
lord, in
allowing
fact,
the other respondents.
the grievance
And-
was with regard to compensatory marks granted to 1563 students, not to other. Nobody complained. There was no other thing. So,
Why are you? We have seen that
yes,
there is nothing when we have also
Yes.
expressed our view.
Lordship,
If
Lordship.
he does not understand, it is our misfortune.
No, certainly not.
To
my
go beyond the order of the Supreme Court. What has been held is binding on us. That's all. Nothing more than he
only
may
some-
argue anything. That's his freedom. But I think as a high court judge or as a high court, we are bound by Article 141.
Lordship.
No difficulty.
My
He may argue anything.
My only submission that it
Sorry.
is not restricted to by
Whatever. The PIL is at the behest of a law student pursuing law course in final examination and claiming himself to be a public spirited person in relation to the National Eligibility Cum Entrance Test 2024. Several reliefs have been claimed in relation to a direction upon the National Testing Agency, within bracket NTA, to release the complete result, that is the marks, comma, the examination centers, comma, the details of OMR, etc., in the individual logins of all the students across the India on its web portal. The allegation is also, the relief is also sought on an allegation of awarding a compensatory marks by the NTA and to conduct the examination afresh. The investigation through an independent agency, that is Central Bureau of Investigation, is also sought for under the surveillance and supervision of the retired judge of the apex court or the high court. Stop. As and by way of an interim order, the petitioner wanted to stay the counseling process pursuant to the said examination. The issue relating to NEET 2024 is spanned over the different high courts of the country, including the apex court. And in one of the writ petition filed under Article 32 of the Constitution of India before the apex court, being a writ petition within bracket civil number 366 of 2024, was taken up, and by an order dated 13th June 2024, the apex court disposed of the same, directing the NTA to proceed for holding the retest of 1563 candidates and publish the results on or before 30th of June 2024. It is further highlighted that in the event those candidates opts not to appear in the retest, their marks would be declared which they secured minus the compensatory marks awarded to them, and they're awarded to them. Stop. So far as the issue relating to compensatory marks awarded by the NTA is concerned, it has been set at rest in view of the order of the apex court in the aforesaid writ petition on 13/6/2024. It is thought to be contended by the counsel for the petitioner that apart from 1563 candidates, there are many other candidates who have been awarded a compensatory marks, but those have been excluded from the privilege of the retest. Is concerned, we do not think that the same can be agitated in view of the the final order passed by the apex court in the aforesaid writ petition on such issues. So far as the other issues are concerned, we have further noticed that the apex court has kept the matter pending and invited the parties to file their respective response. We are not in a position to find out in details the other issues which have been raised before the apex court. So far as, is raised in the apex court. Stop. We also do not find that there has been any fetter put on the High Court to consider the issues raised in the instant public interest litigation in absence of any specific order passed in this regard. The other issues requires adjudication only upon the exchange of affidavits, and therefore we direct the respondents to file affidavit in opposition to filed an affidavit, not opposition, filed an affidavit within
My lord will kindly give
within 24th
24th.
of June.
My lord will only. They'll just come from Delhi. And moreover, my lord, Supreme Court in vacation. So kindly
24th June, reply if any shall be filed, or file it by 30th of June. Reply if any shall be filed within 7th of July. File it. Let the matter be listed on 9th. After 8, we are 9th.
my lord, kindly record.
First of in course of the hearing, our attention is drawn to the fact that the NTA has filed a transfer petition before the apex court today. To stop. Since there is no ওখানে বলেছে না fetter or the entry border, সেই জন্য বললাম এটা করে দাও, ওর উপরে করে দাও।
Also, may I be allowed to come with the supplement through supplement or anything, the further developments, my lord?
With that, take a lead, first start and then come. No difficulty. Yes, call the next.
My lord, my lord, since it's a public interest litigation, my lord, with the leave of my learned senior, if your lordship allows me to submit one thing only.
Sorry. It is, however, made clear that the point of locus
Yes.
of the petitioner, as raised by the appearing respondents, is kept open.